Civil law, civilian law or Roman law is a legal system originating in Europe, intellectualized within the framework of late Roman law, and whose most prevalent feature is that its core principles are codified into a referable system which serves as the primary source of law. This can be contrasted with common law systems whose intellectual framework comes from judge-made decisional law, which gives precedential authority to prior court decisions on the principle that it is unfair to treat similar facts differently on different occasions. Historically, a civil law is the group of legal ideas and systems ultimately derived from the Code of Justinian, but heavily overlaid by Napoleonic, Germanic, canonical, feudal, and local practices, as well as doctrinal strains such as natural law, codification, and legal positivism. Conceptually, civil law proceeds from abstractions, formulates general principles, and distinguishes substantive rules from procedural rules. It holds case law to be secondary and subordinate to statutory law. When discussing civil law, one should keep in mind the conceptual difference between a statute and a codal article. The marked feature of civilian systems is that they use codes with brief text that tend to avoid factually specific scenarios. Code articles deal in generalities and thus stand at odds with statutory schemes, which are often very long and very detailed. Overview. The purpose of codification is to provide all citizens with manners and written collection of the laws which apply to them and which judges must follow. It is the most widespread system of law in the world, in force in various forms in about 150 countries, and draws heavily from Roman law. Arguably the most intricate known legal system dating from before the modern era, where codes exist. The primary source of law is the law code, which is a systematic collection of interrelated articles, arranged by subject matter in some pre-specified order, and that explain the principles of law, rights and entitlements, and how basic legal mechanisms work. Law codes are simply laws enacted by a legislature, even if they're in general much longer than other laws. Other major legal systems in the world include common law, halakha, canon law, and Islamic law. Civilian countries can be divided into those where Roman law in some form is still living law but there has been no attempt to create a civil code, Andorra and San Marino. Those with uncodified mixed systems in which civil law is an academic source of authority but common law is also influential, Scotland and Roman Dutch law countries. Those with codified mixed systems in which civil law is the background law but has its public law heavily influenced by common law, Puerto Rico, Philippines, Quebec and Louisiana. Those with comprehensive codes that exceed a single civil code, such as Spain, Italy, France, Germany, Greece, Japan, Mexico. It is this last category that is normally regarded as typical of civil law systems, and is discussed in the rest of this article. The Scandinavian systems are of a hybrid character since their background law is a mix of civil law and Scandinavian customary law and have been partially codified. Likewise, the laws of the Channel Islands are hybrids which mix Norman customary law and French civil law. A prominent example of a civil law code would be the Napoleonic Code, named after French Emperor Napoleon. The code comprises three components: the law of persons, property law, and commercial law. Rather than a compendium of statutes or catalogue of case law, the code sets out general principles as rules of law. Unlike common law systems, civil law jurisdictions deal with case law apart from any precedence value. Civil law courts generally decide cases using codal provisions on a case-by-case basis, without reference to other judicial decisions. In actual practice, an increasing degree of precedence is creeping into civil law jurisprudence, and is generally seen in many nations' highest courts. While the typical French-speaking Supreme Court decision is short, concise and devoid of explanation or justification, in Germanic Europe, The Supreme Courts can and do tend to write more verbose opinions supported by legal reasoning. A line of similar case decisions, while not precedent per se, constitute jurisprudence constant. While civil law jurisdictions place little reliance on court decisions, they tend to generate a phenomenal number of reported legal opinions. However, this tends to be uncontrolled, since there is no statutory requirement that any case be reported or published in a law report, except for the councils of state and constitutional courts. Except for the highest courts, all publication of legal opinions are unofficial or commercial. Civil law is sometimes referred to as Neo-Roman law, Romano-Germanic law or Continental law. The expression civil law is a translation of Latin jus civile, or citizens' law, which was the late imperial term for its legal system, as opposed to the laws governing conquered peoples. Hence, the Justinian Code's title Corpus Juris Civilis. Civil law practitioners, however, traditionally refer to their system in a broad sense as jus commune, literally, common law, meaning the general principles of law as opposed to laws peculiar to particular areas. History. The civil law takes as its major inspiration classical Roman law, and in particular Justinian law, and further expounding and developments in the late Middle Ages under the influence of canon law. The Justinian Code's doctrines provided a sophisticated model for contracts, rules of procedure, family law, wills, and a strong monarchical constitutional system. Roman law was received differently in different countries. In some it went into force wholesale by legislative act, i.e., it became positive law, whereas in others it was diffused into society by increasingly influential legal experts and scholars. Roman law continued without interruption in the Byzantine Empire until its final fall in the 15th century. However, subject as it was to multiple incursions and occupations by Western European powers in the late medieval period, its laws became widely available in the West. It was first received into the Holy Roman Empire partly because it was considered imperial law, and it spread in Europe mainly because its students were the only trained lawyers. It became the basis of Scots law, though partly rivaled by received feudal Norman law. In England, it was taught academically at Oxford and Cambridge, but underlay only probate and matrimonial law insofar as both were inherited from canon law, and maritime law, adapted from Lex Mercatoria through the Bordeaux trade. Consequently, neither of the two waves of Romanism completely dominated in Europe. Roman law was a secondary source that was applied only when local customs and laws were found lacking on a certain subject. However, after a time, even local law came to be interpreted and evaluated primarily on the basis of Roman law, thereby in turn influencing the main source of law. Eventually, the works of civilian glossators and commentators led to the development of a common body of law and writing about law, a common legal language, and a common method of teaching and scholarship, all termed the jus commune, or law common to Europe, which consolidated canon law and Roman law, and to some extent, feudal law. Codification. An important common characteristic of civil law, aside from its origins in Roman law, is the comprehensive codification of received Roman law, i.e., its inclusion in civil codes. The earliest codification known as the Code of Hammurabi, written in ancient Babylon during the 18th century BC. However, this, and many of the codes that followed, were mainly lists of civil and criminal wrongs and their punishments. Codification of the type typical of modern civilian systems did not first appear until the Justinian Code. Germanic codes appeared over the 6th and 7th centuries to clearly delineate the law in force for Germanic privileged classes versus their Roman subjects and regulate those laws according to folk right. Under feudal law, a number of private custumals were compiled, first under the Norman Empire, then elsewhere, to record the manorial, and later regional, customs, court decisions, and the legal principles underpinning them. Customals were commissioned by lords who presided as lay judges over manorial courts in order to inform themselves about the court process. The use of customals from influential towns soon became commonplace over large areas. In keeping with this, certain monarchs consolidated their kingdoms by attempting to compile customals that would serve as the law of the land for their realms, as when Charles VII of France commissioned in 1454 an official custumal of crown law. Two prominent examples include the Chumwa de Paris, which served as the basis for the Napoleonic Code, and the Saxon Spiegel of the bishoprics of Magdeburg and Halberstadt, which was used in northern Germany, Poland, and the Low Countries. The concept of codification was further developed during the 17th and 18th centuries AD, as an expression of both natural law and the ideas of the Enlightenment. The political ideal of that era was expressed by the concepts of democracy, protection of property and the rule of law. That ideal required the creation of certainty of law, through the recording of law and through its uniformity. So, the aforementioned mix of Roman law and customary and local law ceased to exist, and the road opened for law codification, which could contribute to the aims of the above-mentioned political ideal. Another reason that contributed to codification was that the notion of the nation-state required the recording of the law that would be applicable to that state. Certainly, there was also a reaction to law codification. The proponents of codification regarded it as conducive to certainty, unity and systematic recording of the law, whereas its opponents claimed that codification would result in the ossification of the law. In the end, despite whatever resistance to codification, the codification of European private laws moved forward. Codifications were completed by Denmark, Sweden, Prussia, France, and Austria. The French codes were imported into areas conquered by Emperor Napoleon and later adopted with modifications in Poland, Louisiana, Canton of Vaud, the Netherlands, Italy and Romania, Portugal and Spain. Germany and Switzerland adopted their own codifications. These codifications were in turn imported into colonies at one time or another by most of these countries. The Swiss version was adopted in Brazil and Turkey. In the United States, U.S. states began codification with New York's Field Code, followed by California's codes, and the Federal Revised Statutes and the current United States Code. Because Germany was a rising power in the late 19th century and its legal system was well organized, when many Asian nations were developing, the German Civil Code became the basis for the legal systems of Japan and South Korea. In China, the German Civil Code was introduced in the later years of the Qing dynasty and formed the basis of the law of the Republic of China, which remains in force in Taiwan. Some authors consider civil law to have served as the foundation for socialist law used in communist countries, which in this view would basically be civil law with the addition of Marxist-Leninist ideas. Even if this is so, civil law was generally the legal system in place before the rise of socialist law, and some Eastern European countries reverted to the pre-socialist civil law following the fall of socialism, while others continued using the socialist legal systems. Several civil law mechanisms seem to have been borrowed from medieval Islamic Sharia and fiqh. For example, the Islamic Hawala underlies the Avallo of Italian law and the Aval of French and Spanish law. Differentiation from other major legal systems. The table below contains essential disparities between the world's four major legal systems. Civil law is primarily contrasted with common law, which is the legal system developed first in England, and later among English-speaking peoples of the world. Despite their differences, the two systems are quite similar from a historical point of view. Both evolved in much the same way, though at different paces. The Roman law underlying civil law developed mainly from customary law that was refined with case law and legislation. Canon law further refined court procedure. Similarly, English law developed from Norman and Anglo-Saxon customary law, further refined by case law and legislation. The differences of course being that Roman law had crystallized many of its principles and mechanisms in the form of the Justinian Code, which drew from case law, scholarly commentary, and senatorial statutes, and civilian case law has persuasive authority, not binding authority as under common law. Codification, however, is by no means a defining characteristic of a civil law system. For example, the statutes that govern the civil law systems of Sweden and other Nordic countries or Rome and Dutch countries are not grouped into larger, expansive codes like those found in France and Germany.